Sometimes, we want to write something that will make you laugh and give you a moment to smile. This is something that we like doing. As a result of this, we are going to take a break from managing legal projects and pricing this week. The opposite is true. This section will discuss 8 of the most humorous court cases that have ever been heard. These cases have been heard in the past. It is recommended that you get yourself a delicious cup of tea and a biscuit to prevent yourself from checking your email for half an hour. Number 5. To play golf or not to play golf. To be more specific, what is the question? That is to say, it was, to put it another way, taking into consideration the specific circumstances of this case. The court was entrusted with evaluating whether or not walking was an essential component of the sport of golf. As a child, Casey Martin, a professional golfer, was unable to walk for extended periods since he was born with an illness that prevented him from doing so. It came as a disappointment to him when he found out that the Professional Golfers Association, PGA, had denied his plea to take part in a competition that required him to use a buggy rather than walk. They indicated that it would be to Martin's advantage, and they also mentioned that walking was an integral part of the game of golf. Martin would thus have an advantage. Justice Antonin Scalia will conduct a scathing analysis of the discriminatory strategies employed by the Professional Golfers Association, PGA, which will be presented in the following sentence. It is a pain. We, the justices, are obligated to face what is irrefutably a tremendous responsibility, the statement read. With the critical role of establishing what constitutes golf, the United States Supreme Court has been granted this responsibility. This responsibility has been handed to the Supreme Court. I am sure that the framers of the Constitution fully expected that sooner or later the paths of golf and government, the law and the links, would once again cross, and that the judges of this august court would someday have to wrestle with that age-old jurisprudential question, for which their years of study in the law have so well prepared them. Is someone riding around a golf course from shot to shot a golfer? Greetings, Mr. Antonin Scalia, the Justice. Number 4. There was a young man from Nantucket who was looking for the sake of this particular instance, the structure of the ruling itself is more important than the particulars of the disagreement. A more particular example would be the fact that the judge wrote his verdict in the form of a limerick. The judge could use some improvement in his techniques, as seen by the fact that the first 2 lines do not rhyme. There is a possibility that you should keep working during the day. A group of farmers from Gaines had a plan in mind for their business. This constitutes a substantial quantity of fraudulent activity. The payments for cotton, on the other hand, began to smell awful, like eggs that had gone bad. The unfortunate Uncle Sam was the target of a robbery. That would be Justice Goldberg. Number 3. May I ask for your forgiveness? The following item on our list is also chosen, but this time it is more for the structure than it is for the case that is being stated. A judge from India's High Court delivered a verdict that was so convoluted that it was overruled by the Supreme Court. This particular case was one of the cases that the Supreme Court of India overturned. Because we are being entirely truthful, we have been wondering about the relevance of the text that is about to be presented for close to an hour. Are there any individuals who would be ready to shed some light on this matter? The subsequent discussion is of the learned executing court as it is pronouncing its impugned rendition, overlooking the important and germane evidence, and not appreciating its worth. This is the result of the discussion that was described earlier. It is safe to say that this concludes the discussion that was addressed earlier. All of the aforementioned material that was in existence before the knowledgeable executing court was disregarded, and the influence that it had was diminished in a manner that was not sustainable by him. Because of this, the order that is being questioned is characterized by a perversity and a hideous absurdity of misappreciation of the information that is on record. This is because the information is being misappreciated. As a result of the BBC. Number 2. An innuendo made a court. There are times when the life of a judge could become repetitive, and this is feasible. When each side is attempting to make their case, it is necessary to listen to defendant after defendant and lawyer after lawyer as they each express their perspective. To our great relief, some judges take pleasure in utilizing their decisions as a means of bringing some excitement to the proceedings. Maybe only for those who are paying attention to what is being said. An excellent illustration of this is the case of Grill v. San Antonio. According to the information that was included in the paper, the state of San Antonio was making an effort to prevent exotic dancers from wearing anything other than a bikini top. The verdict was a heaven of double entendre because it was a result of the club's attempt to get an injunction that would prevent the cities from putting this statute into effect. We deeply regret to inform you that the plaintiffs did not meet with success. The following is a list of certain aspects of the ruling that are particularly noteworthy. If the parties choose to take this case to trial on the merits, the court strongly recommends that they engage in appropriate discovery interaction as they navigate the highs and lows of the litigation process to increase the likelihood of reaching a solution that is satisfactory to all parties involved. In addition, the court has been tasked with the job of writing an ordinance that addresses semi-naked dancers for the second time in its history. Number 1. Grill is opposed by San Antonio. It was never even brought before the court. The name of our final submission provides the impression that it was not even submitted to the court during the proceedings. There was a quarrel that was meant to be tried in court, but it was instead resolved outside of court. As a reaction, Justice Martin Sheehan of Kentucky penned a cancellation order that was so brimming with happiness that it is worthy of a place in this video. Judge Sheehan noted that the news made him happier than a tick on a fat dog because the court is otherwise busier than a one-legged cat in a sandbox, and quite frankly, would have rather jumped naked off a 12-foot stepladder into a 5-gallon bucket of porcupines than have presided over a trial of the herein dispute, a trial which, no doubt, would have made the jury more confused than a hungry baby in a topless bar, and made the parties and their attorneys madder than mosquitoes in a mannequin factory. Did you like it? Tell us what you think of the video in the comments section below. And don't forget to subscribe to our YouTube channel for more interesting videos.